If you've been injured, what's the purpose of your attorney sending out a demand letter? First of all, a demand letter is a position statement about where your case is in regards to liability and all your legal claims and the full extent of your injuries and damages. And like its name implies, it's usually put in a letter or an email. Sometimes we do it by video and do video demands, but it has just a round statement of fully encompassing all of your claims. We send it to insurance adjusters in car wrecks, trucking wrecks. We send it to the insurance company. Also, in some cases where there's already a lawsuit filed, we'll send it to the opposing lawyer, the insurance lawyer. Usually in medical malpractice cases or aviation cases or trucking cases, there's already been a lawyer assigned, especially in trucking cases. How long does it take to get a response from a demand letter to try to get your case resolved? Well, the insurance companies, usually after they receive it, it takes usually a couple of weeks to a month. Sometimes it could take longer. Sometimes they'll say, well, we need more time to evaluate this. They may ask for more information, such as missing medical records or medical bills. And then other times they'll think they've got sufficient information on your case and they'll give you an offer. And that initial offer is always, without exception, a lowball offer. It's always, usually it's less than your medical bills sometimes. I always tell my clients, sometimes like no good deed goes unpunished. Sometimes we're trying to work with them. But it's just get ready for that. They're going to give you a low offer. It's just the way that they're programmed to do this. Remember that you can settle your case at any time. So when is a good time to send a demand letter? Well, sometimes you can settle your case too early. For example, if you have a trucking case and the trucking company is just so adamant about trying to get to a mediation and settle your case or get a demand from you, sometimes that's a red flag. Sometimes there is something they're trying to hide and they don't want to have it exposed in litigation. For example, if you've been involved in a trucking collision and their driver has a history of multiple wrecks or a drug violation after this wreck happened, you may not know that. It may not be fully evident because truck drivers have to be tested shortly after a wreck, and they may have appeared fully competent at the scene to the police officer, but they may have drugs in there. So they're saying, hey, John, come on, please settle this case as quickly as you can. I'm like, I kind of smell a rat. So we always want to settle our case, but sometimes that's an example of how you can settle it too early. Can you settle your case too late? Yes. Sometimes it might be advantageous to you in certain situations to settle your case sooner rather than later, maybe too soon. And let me explain that. When I'm evaluating your personal injury case, I'm looking at who's at fault, what are your harms, what are your damages, what are your medical bills, and how much insurance coverage is available. Sometimes there may not be enough insurance coverage, particularly in a car wreck case where the person who hit you rents an apartment, they've got an older car, they've got very low levels of insurance, and they don't have any assets for which to claim. And you don't have a lot of uninsured or underinsured motorist coverage. Sometimes in those cases, for example, if there's $50,000 of coverage and you've got that same back injury and you need a back surgery, I want to go ahead, if I'm pretty certain that there's not a lot of money available in your case, I want to settle that case sooner rather than later before your medical bills get really, really high. So right now you might only have $5,000 or $10,000 in medical bills, but you need a surgery, and that surgery is going to cost another $50,000. But why? I don't want to take that $50,000 in limits and have to pay it all to the health insurance company. So sometimes we can settle your case earlier than I really want to, but because it puts you in the best financial position overall. And in those cases where you do need a surgery, after you settle your case, at least in Tennessee, you can still go get the surgery later after you settle, and your health insurance will pay for it, and you don't have to pay them back after you settle your case. So a little complicated. It's not a great position to be in, but sometimes you can settle your case too late, and that's an example. What if you don't want to accept their best final offer? Well, we continue to push the case in litigation. Usually they will offer more before trial, not always. So those are things that we look at. We just continue to push the case to the next step. If they're not offering good money, I always tell my people, what's the next step? We either need to try this case, good, bad, or ugly. We're going to do the very best to get our clients the very best result. But we can't just say, I'm just not good at begging insurance companies for money. That's what they made the courtroom for. That's what we do. That's our field. That's where we do our battle. And that's what we train for. We only try about 2 or 3% of our cases. There's a 98% chance your case is going to settle. But in those 2 or 3% of the time that we do go to trial, we want to have the very, very best outcome for you. If you have any questions, leave them in the comments or call us at Griffith Law. Thank you.